Am I protracting the proceedings? Or I did not tell the trial court to pass wrong orders? I'm sure your lordship would certainly agree with me that I have a right. If, in my wisdom, my lord, if I were to see that the order that is passed by the trial court is incorrect, inaccurate, illegal, unacceptable, I am not entitled to question it. I am certainly entitled to question it. Ultimately, it is for your lordship to decide whether what I have questioned is right or wrong, whether I am justifiable or not. Is it with ulterior motives that I have filed this petition and questioned the order which came to be passed by the trial court? But I am a little bit pained because this should not have been the statement of objections which came to be filed by the prosecution as stated in paragraph 19. Next day, I make a motion before this honorable court on 13/11/2024 to take up the matter in the afternoon session of the day because on 14th, my lord, the approver was summoned for the purpose of giving evidence in the case. Your lordship may recall to your lordship's memory. Leave alone.
SQ 164.
SQ 164.
Pardon can be granted.
Can he grant it on the basis of such kind of bald applications? Is the question that warrants consideration at your lordship's hands. Well, kindly permit me to take your lordship. Now kindly read the encomiums which the court would give.
Yes, I've seen.
It is rather unfortunate to note that in spite of providing sufficient opportunities, the prosecution are unable to furnish appropriate details of the witness they are intending to examine. Repeatedly, the checkered history of the case indicates that the case was posted for fixing the date of trial, and thereafter some witness lists were being filed by the prosecution without ascertaining the list which they had filed earlier. Earlier, they would file one list, but subsequently the entire list gets changed. In the next list, my lord, instead of eyewitnesses, recovered witnesses, punch witnesses, handwriting expert would come into picture now. Doesn't matter. But he came to be examined by the prosecution with regard to the charge that is framed against the accused for an offence which is made penal under the provisions of the Arms Act. But then the trial was adjourned to 16/11/2024, on which date, my lord, also the prosecution was required to keep two other witnesses who would corroborate the statement of the approver.
ಇವರೇ ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಪೇರ್.
SPP ಬೇರೆ ಇವರೆಲ್ಲ ಇಲ್ಲಿಯವರು ಈ ಅಬ್ಜೆಕ್ಷನ್ presumably he was not kept informed about the encomiums that are given
Is not
or the
informed.
compliments that were given by the trial court. But he now, in the statement of objection, he would put the blame on us, saying that we have been protracting the proceedings. That would be the first point. To paragraph 19, it is incorrect, wholly incorrect. He should not have made this. That is why, my lord, I want to counter his submissions. It is submitted, my lord, the order itself was not signed. I shall show to your lordship on 30th now. Well, it is submitted that the conduct of the petitioners in approaching this honorable court at a belated stage, after a delay of almost 15 days since the passing of the impugned order, is only of the thought the attempt to delay the trial. Well, the order came to be passed on 30th October, no doubt. Well, may I just request your lordship?
Uploaded on 11th.
Well, that signature was put on 11th. I shall take your lordship. No, one must be careful and cautious in making certain atrocious allegations. What for it was made? Is it to prejudice the mind of the court? What they say is, no. Issue a direction for recording a statement under 164. But 164 does not come into play no sooner the inquiry or trial commences. It is only during investigation. The court has no jurisdiction at all, either to direct or itself record the statement under section 164. Because till such time, my lord, he is treated as a witness for the prosecution, he is an accused. Kindly go to page 148 now. Kindly permit me, my lord, I shall skip, my lord, paragraph 1 and 2. I shall take your lordship to next paragraph.
He has not quoted how he is going to support the prosecution. So
Yes, my lord, that is the basic essential ingredient to invoke the jurisdiction of the court under section 306. What is his role? What is the role of the other man? What is it that he is going to depose? Well, what the trial judge, I shall take your lordship, did was, no, I am going to give you pardon, but I shall wait whether you are going to support the case of the prosecution or not. Therefore, I will direct the magistrate to record a statement under 164. I will secure it. I will find out. I will read it. Then I will give you pardon. That is, my lord, if I may say so with utmost respect, my lord, that is not the duty of the presiding judge. Their statements are there. Their statements under 164 is also there, unless and until they say that from the evidence which we have been able to collect subsequent to the notification issued by the state government is certainly insufficient to make out a case against the accused, then only, my lord, the court can do it. That is what they would say here. And the same could not be proved by the available evidence by the prosecution. Well, kindly read the next paragraph. This would be very, very important. In this regard, it is respectfully submitted that this honorable court may be pleased to direct the petitioner to record his confession statement under 164 subclause 1 CRPC, and after perusing the recorded confession statement of the petitioner, prosecution will be in a position to take the appropriate decision. Right. Well, they would make a request to the court to direct the accused to make a statement under section 164, which the court can't do it. Even the magistrate also can't record a statement under 164. I shall take your lordship to the provisions little later after taking your lordship to what is the order which can be passed by the trial court. May I request your lordship to kindly turn to, it commences at page 124. Well, the relevant paragraph, the order commences from paragraph 17 at page 142. But this order came to be passed by the trial court on this application on 29th of April 2023. This order has attained finality. Commences at page 124. Kindly go to page 142, paragraph 17. My lord gets it. I have gone through the sections 306 and 307 and 308 of CRPC. There is no bar either under section 306 or 307 CRPC to tender pardon to an accomplice. And the court can tender pardon any stage of the investigation or inquiry into or the trial of the offense. But there is no quarrel with regard to the jurisdiction of the court during inquiry or during trial. Absolutely no quarrel. The court certainly has a jurisdiction under section 300.